Welcome to our YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we will be discussing the concept of restrictive covenants, otherwise known as negative covenants. And these are restrictions that are placed within an agreement or contract that preclude one party from undertaking a specific action, such that they must abstain from taking that action as part of the contractual agreement. And though they also arise in financial instruments, real estate contracts, property agreements, what we're going to be focusing on primarily are certain restrictive covenants that is found in business agreements as well as in certain employment agreements. And those pertain to non-competition, non-solicitation, and confidentiality. And these are typically found together, and it really depends on the arrangement that the parties have with one another and the bargaining power that starts to dictate the distinctions and the level of recognition and enforcement that the courts have with respect to each of these restrictive covenants. So let's go through each of them separately. So the highest level one that we're talking about is non-competition, being that the one party requires the other party not to compete with them. So it's to engage in no business of the specific business that is defined in the agreement. Now, this is the highest level of restrictive covenant among the three. And as such, it requires the most faithful achievement and appropriate standards to have it enforceable. The next is non-solicitation, and this can pertain to non-solicitation of customers, non-solicitation of employees, non-solicitation of contractors, and the like. So you've got the internal and the external arrangements where they're saying you cannot go out and actively pursue these specific individuals and businesses, because to do so would be in breach of the covenant, because this is internal information that's privy to ourselves, but more so it is business development that we have undertaken as a business, and you cannot breach that. The final is confidentiality or non-disclosure, and that pertains to specific practices of the business and information of the business. This can be trademarked information. This can be information that's been developed and known only within the business. Naturally, if it's out in the public domain, it creates a different sphere, and that cannot necessarily be subject to confidentiality. It is where it is internal to the business and the knowledge is there. So why are there these three different levels, and what's the discrepancy between them? Well, it's almost on a hierarchy where confidentiality and non-disclosure is almost implied, even if it is not specifically written in the agreement, although it's always beneficial to write it in the agreement. It has the lowest standard for enforceability because it is expected and it is a normal business practice. As you move up the chain, then the requirements on the party seeking to enforce it become higher and higher. Hence, the non-solicitation aspect requires that the party actively solicit to be in breach. The fact that a party comes forward and engages with somebody who is under a restrictive covenant has the potential for being outside the terms of the restrictive covenant and allowing that party to engage with the party whom they would otherwise be restricted from initiating communication, but not necessarily receiving it. The most onerous and thus the most difficult to enforce is non-competition, because it requires a party to preclude from engaging in business. And unless there is equally bargaining power between the two sides, such as where one shareholder is selling their interest in a business to their other shareholder, and part of the payment is tied to their not competing in that particular business, it can be difficult to enforce that. For example, to say that an employee of a company who is at a very low bargaining power, if any, can be forced to not compete in the particular business in which they are engaging in is very difficult to enforce. There is a potential with respect to employees to enforce the lesser of the restrictive covenants, but this highest level of restrictive covenant is the most difficult to achieve because it goes against more fundamental principles, including that of allowing a party to make a living. So the courts are very reluctant when there's unequal bargaining power between the two parties to enforce this higher level of restrictive covenant. And this brings us to another aspect of where restrictive covenants can be taken back, and that is as to their breadth, meaning how wide-ranging are they? Because if the time periods that are being sought or the geographic areas that they're sought to encompass are so broad that it makes it difficult for the party under the restrictive covenant to actively engage in their business, the courts are not prone to like that. And yes, you can have savings clauses that pull this back, which is appropriate, from a contractual standpoint. But you want to be careful with that because you do not want to seem as overly aggressive. For example, when a dentist hires a young dentist to work for them and imposes very restrictive, very broad and sweeping restrictive covenants, not allowing the younger dentist to practice within a city of 1 million people. This creates an unfair imposition as to enabling that person to go and decide to leave their job and to find appropriate employment. It's one thing to restrict them from working next door. It's another thing to restrict them from working 20 kilometers away in their chosen profession. And hence, you need to be extremely careful when it comes to restrictive covenants and how far you are looking to take them and what kind of imposition they are going to have on a particular individual, such that you need to understand the spectrum and the ramifications so that you don't overstep them and thereby have a court eventually negate them so you have no restrictions whatsoever, which is not beneficial to yourself. And hence, when you impose or seek to impose restrictive covenants in your contractual agreements, you really should have the insights of a lawyer and the review of a lawyer to make sure that you're staying onside as opposed to being offside, and thus potentially losing all the rights that you would otherwise have gained. Thank you.